All right, let's talk about something that happens in hospitals all the time, but is hugely misunderstood. When a patient decides to leave against medical advice, or AMA. We're going to break down the myths versus the reality.
So you can probably picture this, right? A patient wants to go home, a nurse hands them a form, they scribble their name on it, and boom, they're out the door. A lot of people, even some doctors and nurses, think that signature is like a legal silver bullet, a get-out-of-jail-free card if something goes wrong. But is that actually true?
Well, the short answer, coming straight from the legal experts, is a big, fat no. That signature is not a legal panacea. It's not this magic wand that makes all legal liability disappear. The truth, as you might guess, is way, way more nuanced than that.
Okay, so if it's not a silver bullet, then what is it for? When it's done the right way, an AMA discharge does provide some really important legal protection. The best way to think about it is like a shield that's built on three crucial pillars.
So pillar number one is what's called termination of duty. This is the legal way of saying that for this particular medical issue, the doctor-patient relationship is over. The provider's duty to keep treating you for that problem has officially ended. It's like drawing a very clear line in the sand. Pillar number two is assumption of risk. And this one's a big deal. It's a legal defense where the hospital can basically say, look, we told the patient everything. We laid out all the potential consequences, even the really scary ones like permanent harm or death. And they chose to accept those risks. See how that works? The responsibility basically shifts from the provider to the patient.
And finally, pillar number three, the form itself. This is the evidence of refusal. Now, the paper isn't magic, but it's a super important piece of proof. It's the physical record that a conversation happened and that the patient explicitly said no to the recommended care, knowing the risks.
But here's the thing about shields, they can crack. And if those three pillars we just talked about aren't built on solid ground, this entire legal shield can just shatter into a million pieces. So let's dive into the three things that can cause it to fail, big time.
All right, failure number one, and this is probably the most important one, lack of capacity. Think about it. If a patient is drunk or in the middle of a serious mental health episode or their thinking is impaired for any reason, they legally cannot give informed consent. They can't assume risk. If a provider lets that person sign a form and walk out, that's not a defense. That's straight up potential negligence.
Next up, we have inadequate disclosure. This is huge. The courts don't just want to see that a warning was given. They want proof that the risks were explained in crystal clear, specific terms. Why? Because a patient can only legally refuse something if their decision is truly informed. If you don't give them all the info, their refusal doesn't count.
And just look at the difference here. It's night and day. On one hand, you have a doctor saying something vague like, you might feel worse. That's legally pretty useless. But on the other hand, a doctor saying, leaving the hospital right now could result in a fatal heart attack. See? That is specific. It's scary, and it's legally strong.
And the third way this whole thing falls apart is poor documentation. That signature on the form, it's just the beginning. The real meat is in the medical chart, because in the legal world, there's a simple rule. If it wasn't documented, it didn't happen. The entire conversation, what risks were discussed, what the patient said, why they wanted to leave, all of it needs to be in the notes. So what does this look like when it goes wrong in the real world? Let me tell you, the consequences can be absolutely devastating. Let's look at a case. This is the tragic story of Michael Cleveland. He goes to the ER with chest pain while shoveling snow. The doctor there apparently misdiagnoses him, doesn't even run some basic tests like an EKG. He gets sent home without signing an AMA form, without being stabilized, and shortly after, he dies of a heart attack. From a legal standpoint, this was a complete breakdown. No diagnosis, no warning of the real risk, and no AMA documentation at all. The hospital's defense had absolutely nothing to stand on. Now, the specific settlement amount in that case is private, as they often are, but cases like this, these failure to diagnose lawsuits, they can easily result in settlements well over $1 million. It just goes to show you the massive financial and legal stakes we're talking about when this process isn't handled correctly. Okay, so now that we know all the ways this can go wrong, how do you do it right? How do providers forge a legal shield that's actually strong? Well, it all comes down to following modern best practices. It's really a four-step process. Step one, you have to formally assess the patient's capacity to make a decision and, you guessed it, document it. Step two, offer them alternatives. Maybe they can take pills at home or see a specialist tomorrow. It shows you're trying to reduce harm. Step 3. Explicitly tell them you are welcome back here anytime, no questions asked. And document that too. And step 4. This is a big one. Don't try to coerce them. You can't threaten them with things like, oh, your insurance won't pay for this visit if you leave. Not only is that a myth, but it can make the hospital even more liable. And when it comes to documentation, this is basically the essential checklist. You need to note the patient's medical status, the specific risks you told them about, the benefits of staying, what other options you gave them, and, this is key, their stated reasons for leaving and that they acknowledged understanding the risks. This is the kind of detail a legal team will be searching for.
So, let's boil all of this down. What's the real takeaway here?
Here it is. The true legal standard isn't about getting a signature on a piece of paper. It's all about proving something called informed refusal. That means you have documented proof that a patient, who was of sound mind, fully understood the very specific, very bad things that could happen, and chose to leave anyway. The legal power isn't in the ink. It's in the proof of that conversation.
And that really leaves us with one final and I think very powerful question to think about. Whether you're a patient or a provider, ask yourself this. Is your process built just to check a box and get a signature? Or is it truly built to make sure there's genuine understanding? Because when it comes down to it, legally, only one of those actually matters.